So data from the Investigating Police Directorate, that's IPID, shows that no action has been taken against a third of officers accused of misconduct. In fact, the Sowetan newspaper today did a great spread on those figures. Let's unpack some of the issues with legal expert advocate Deon Pool. Very good evening to you, advocate. Good to have your time. So when you look at the piece published today in the paper and the lack of action, if you will, in majority of the cases that IPID has basically decided on and found against officers, how much faith should those SANDF trainees who we saw being assaulted in the video place in the IPID process?
Good evening. The problem with IPID, I think, as we see it, is, or not the problem at least, it's more a limitation of their mandate. The IPID Act allows for the Independent Investigative Directorate to investigate complaints that have been referred to it by concerning the conduct of members of the police, which of course includes the VIP Protection Unit, the SAPS, and then the Metro Police. Once they've investigated, they make certain recommendations, and those recommendations go to the Provincial Police Commissioner of, in this case, Gauteng, and he, in terms of the Act, is then directed to, within 30 days, implement those recommendations, or alternatively, take certain steps in respect of the disciplinary procedures that IPID has then recommended on. The problem seems to be that IPID doesn't have any means of ensuring compliance with that recommendation beyond that point. There is a provision in the IPID Act which provides for IPID to lay a complaint. Not cooperating with IPID is a sanctionable offence. It's a criminal offence. However, I have not had experience of any matter ever going to court in respect of IPID complaining that they have not had the necessary cooperation.
And is it that what IPID says to the SAPS needs to happen is purely disregarded, or because the people who are supposed to be implementing the sanctions are just simply not in touch with what should be happening and, in fact, even following up on the cases and directives?
Well, I think it's a combination of various issues. First of all, IPID has complained in the past, like many of these independent or so-called independent structures that are responsible for maintaining compliance and oversight, that have been starved of resources. Their main concern has always been that they don't have enough resources in order to do what the Act mandates them to do. And then, of course, they invariably have complained that they don't get the necessary cooperation from either members of the South African Police Force or its overall structures, the command structures. And then, of course, it depends on the nature of the recommendations. I fail to understand why, once these recommendations have been referred to the provincial or national commissioner for that purpose, within the 30 days that certain steps are not taken. However, and I come back to the point that it appears that IPID then has got no other recourse than to say, we've done the investigation, we've sent a recommendation, and unfortunately, whatever steps need to be taken thereon is dependent on how those recommendations are to be implemented or viewed by the persons incumbent in every province to do it, who report to the Provincial Police Commission.
And it's troubling, Deon, because IPID is not the only authority in this country that has an issue with government, whatever department it may be, in fact, ignoring recommendations. The Office of the Public Protector has lamented the same issue. When you look at the Auditor General, it's been much of the same. Even at AG level, there was calls to empower the office, give it more teeth so that we see an actual change. Now you've got, as you're telling us, in fact, as the stats themselves from IPID lay out, what is a wholly inadequate picture as far as SAPS consequence management, where officers are found to have been guilty of wrongdoing. So how much more power do you think IPID would need for its recommendations to begin to bite? So basically, for the victims to see some level of justice?
Well, first of all, IPID's mandate currently only extends as far as disciplinary procedures are concerned. IPID can advise a complainant to go and open a case against the police officer, but of course that case has to be investigated, and you are asking members of the South African police to investigate and inform on their colleagues in most instances. So IPID needs, although IPID investigators do have the same powers as police officers when it comes to investigation, the Act does not provide for the same sanction that they can simply direct either an officer to be arrested or immediately suspended. Those recommendations, to the extent that they would apply, are referred to the police commissioner, who is supposed to then employ the various disciplinary procedures that are available in the police regulations as far as their members are concerned. IPID purely receives a complaint, investigates it to the point that it is able to do so, makes certain findings, and then passes on the recommendations in accordance therewith. And whether those recommendations are agreed with or not at the end of the day seems to be up to the eventual command structures of the police.
And where there is action, Deon, there's also an issue about the sort of sanction handed down. In fact, in the report today, it says in the article that the sanction for common assault, for instance, would range between verbal and written warnings based on the IPID statistics. And when you look at what happened in that video from Fourways, for instance, you wonder if a written warning, a verbal warning, would be sufficient punishment when you consider just the extent to which those people were assaulted.
I prefer not to comment on the specific instance that is in the news currently, because it is subject to investigation and there are members of the public who are involved in those matters. But invariably, the sanction, there's always the issue that punishment must fit the criminal as well as the crime. And then you've got variances of common assault, because me threatening you is an assault, and me slapping you is an assault. There's degrees of assault. So the sanction might be appropriate in respect of the specific circumstances we wouldn't know. But the question remains is, at which point do we now get, where do you draw the line in respect of holding police officers accountable as far as their conduct is concerned? IPID can investigate that and make a recommendation, but it's for the internal disciplinary procedures alone. It cannot go and make any findings regarding the truth of the matter or whether a sanction is appropriate or not, or those kinds. That is left up to the internal structures of the police themselves.
So unless those structures work, much of it is pointless, right?
Yeah, there's clearly a disconnect between what the idea that the public might have insofar as IPID is concerned, and what IPID is actually doing, and how the police are, I want to use the word respecting in a very loose fashion, how they are respecting whatever IPID has to say when they make their eventual recommendation.